This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Trump administration has been locked in a showdown with the federal judiciary as judge after judge has blocked President Trump's agenda. And the country's chief law enforcement officer, Attorney General Pam Bondi, has repeatedly attacked federal judges.
They're deranged is all I can think of. I cannot believe. I think some of these judges think they are beyond and above the law, and they are not. We are in court every day fighting against these activist judges. We're not going to stop. Many of them should be recused from these cases. They will be recused from these cases. We're appealing them. Look at Chuckin. Look at Judge Chuckin with the EPA trying to control our money. Judge Chang trying to control the money of the U.S. aid. Judge Reyes, look what she did to Pete Hegseth. These injunctions have allowed district court judges to be emperors. They vetoed all of President Trump's power, and they cannot do that.
The Justice Department went from rhetoric to legal action, filing an unprecedented lawsuit against all 15 federal district judges in Maryland over an order that grants a 2-day stay of deportation to migrants who file habeas corpus petitions. This week, Maryland's federal judges responded by asking a court to dismiss the lawsuit, saying it was an assault on the separation of powers. My guest is retired federal judge Andre Davis. He sat on the U.S. Court of Appeals for the Fourth Circuit, and he's one of more than 40 judges working with the nonpartisan group Keep Our Republic's Article 3 Coalition. Thanks so much for joining me, Judge Davis. You were once a federal judge in Maryland. What's your reaction to the Trump administration suing the entire federal bench in the state?
Well, June, I don't know that the language exists, honestly, to express my reaction. The words that have been used, of course, unprecedented, extraordinary, all of which is true. But honestly, I don't have a rhetorical device myself to capture just how extraordinary it is for the executive branch to actually file a lawsuit, a purported lawsuit, against an entire district court bench, naming each of the individual judges in their official capacities over the court's use of a fairly routine administrative order. It's just off the charts extraordinary. That was my initial reaction. And the more I've thought about it over the last 2 weeks, that reaction has really solidified inside me.
This suit is about a standing order by the chief judge that stopped the administration from deporting migrants who filed a habeas petition for 2 days. The Maryland judges say that these kinds of temporary stays are common and pointed to similar stays in the Fourth Circuit, but the Trump administration says it's extraordinary.
What's extraordinary is the administration's decision to challenge the order through the means of a purported lawsuit. The order is absolutely routine. As you just said, the Fourth Circuit, the Ninth Circuit, a number of circuit courts of appeal use these kinds of standing orders to manage their docket, to pace the work, as well as a number of district courts around the country. So this is as routine as it gets, honestly. And the idea that somehow this is different because it requires a 2-business-day hiatus to give a judge a full opportunity to consider a request for emergency relief, as I say, the rhetoric to capture the extraordinary nature of this act by the administration honestly just doesn't exist.
Do you see this as a ratcheting up of the Trump administration's assault on the judiciary, or is it an attempt by Trump to further expand executive powers, or both, or neither?
I'll have to leave that for others to judge. What I can tell you is that, one, aggressive enforcement of the executive branch's priorities, that's a decision for an administration as to how they wish to pursue their priorities. What's not for any administration to do is to call into question the rule of law, the legitimacy of courts, and the separation of powers, which is exactly what this action does. If they want to be aggressive, they can be aggressive, and they are aggressive. But the court is entitled, and not just entitled, but the court is duty-bound to protect its jurisdiction, to ensure that it can fairly, deliberately, unbiased way decide the disputes that come before the court. And so an administration that sets up a system in which an effort can be made to deprive the court of jurisdiction, if that's what's happening, by these rushed removals, then the courts have a duty to make sure that that jurisdiction is protected.
I want to go over some of the arguments the judges make in their dismissal motion. As you referred to, they argue that the lawsuit is a violation of the separation of powers. Quote, a lawsuit captioned Congress versus executive or vice versa would be dismissed in a heartbeat. A suit effectively captioned executive versus judiciary fares no better.
Well, first of all, how can the United States sue itself, right? I mean, it's like this part of the United States suing that part of the United States. It cuts to separation of powers in this way. The co-equal branches of government are co-equal. Each has primacy in its lane, and the judicial lane is the adjudication of disputes, both between the government and non-governmental actors, as well as between private parties, including corporations, nonprofits, and individuals. That's how the system is designed. That's how it has worked for nearly 250 years. And now we have this situation where one part of the government claims to be able to coerce another part of the government to do what it wants. Think about it, Jim. Just take a step back from it for a moment. Here we have the executive branch asking a single district judge from somewhere in the country to police the administrative practices of another group of federal district judges. I mean, it's enough to give you a headache. That can't possibly be consistent with separation of powers. The executive branch is purporting to capture one part of the judicial branch to use as a cudgel against another part of the judicial branch. Thomas Jefferson is turning over in his grave.
So another argument that the Maryland judges are making is that the court is shielded under sovereign immunity and that the judges and court clerks are protected under judicial immunity.
Absolutely. Full stop. In my judgment, there's simply no legitimate response to that other than that's correct. It's absolutely correct. There's just no answer to it.
Because all the judges in Maryland are being sued here, the Fourth Circuit appointed a judge from outside the circuit to hear the case. So the circuit appointed Virginia federal judge Thomas Cullen, a Trump appointee, to handle the case. He's only been on the bench since 2020, and he hasn't handled any high-profile cases. Any idea why he was chosen?
No, I don't. I can tell you generally what the court tries to do when they have to choose judges who are willing to go out of district or out of circuit for a special assignment. They look at, I think, number one, frankly, whose workload at the moment will allow that judge to take on a little bit of extra work. I myself, in fact, on two separate occasions, when I was on the Fourth Circuit, I volunteered and was appointed by the Chief Justice to sit as a visiting judge in the Third Circuit in Philadelphia in a couple of cases where the entire bench of the Third Circuit, all 17 judges, for a couple of reasons, were recused from hearing the case. So the Chief Justice appointed myself and two other visiting judges to go to Philadelphia to hear argument and decide the case. So it does happen from time to time. And as I say, one of the first considerations is who among you can devote additional time to this extra work. And I suspect that was a principal reason. But, any district judge willing to do it and able to do it would have been fine, I'm sure, to the Fourth Circuit.
The Maryland judges also say that this wouldn't be the last such lawsuit if it's not quickly rejected. Do you see this as a broader attack by the Trump administration on the federal judiciary as sort of the first step? Or is it more isolated, targeting the Maryland bench, which has handed down a lot of decisions curbing the Trump administration in high-profile cases like that of Kilmar Abrego-Garcia?
I frankly think it's impossible to believe, based on what has occurred up until now, that this was a one-off, that if this were somehow to succeed, it's hard to imagine that this practice wouldn't see itself duplicated around the country. Why was Maryland chosen in particular here? I don't know. I can't answer that. There have been rulings that the executive branch has objected to all over the country on a number of issues, including the issue present in this instance of expedited removal. But I don't see a world in which, if this case somehow succeeds, even succeeds at the motion to dismiss stage, which I don't believe it will, it's going to be duplicated around the country if it succeeds here.
So you think that the motion to dismiss will be granted?
I do believe that.
The Trump administration basically appeals every decision that goes against them. Do you think that this case will end up at the Supreme Court?
That's a good question. If they choose to appeal, just as I believe the case is going to be dismissed at the district court level, I believe that the Fourth Circuit will reject any appeal that's taken. And frankly, I believe that the Supreme Court will reject any appeal that is sought from them. But whether such an appeal or a petition for cert eventually gets filed is entirely up to the Department of Justice and the administration.
And Judge Davis, why did you join Keep Our Republic's Article 3 coalition?
Oh, it took me all of about a half a second when I learned of the Article 3 coalition and the extraordinary retired judges who I know, many of them are my friends. I've served with them over many years. The idea that we retired federal judges have a special voice that we can use to educate the public, to speak on behalf of the federal judiciary, which we all love and respect and honor so much. The idea that we can have some space where people can hear us, question us, check our answers against historical sources, and assess our experience to lift the public's understanding of the importance of the rule of law, the separation of powers, the imperative of judicial independence. All of that together, June, is what immediately prompted me to say, yes, I want to be a part of this. I want to add my voice to those of other retired judges who will raise the understanding of the public, and that's really our audience, the understanding of the public about how courts work, the rule of law, and the foundations of our democracy, because there's a real need for additional efforts in those regards. We are not the only ones doing this work, and we are not doing all the work that needs to be done in this area. But I think retired federal judges have a legitimacy and a claim to legitimacy that I think many, many members of the public will respect, listen to, and learn from. And so that's why I'm very happy to be a part of this extraordinary coalition.
Thanks so much for joining me, Judge Davis. It's great to get a judge's perspective on these issues. That's retired federal judge Andre Davis. President Donald Trump has been very open about his plans to use redistricting to help Republicans retain control of the House in the 2026 midterm elections. Trump has pushed to get Republican lawmakers in Texas to redraw the state's congressional maps in favor of the GOP, saying it would add as many as 5 seats for the party.
5, I think we get 5. And there could be some other states. We're going to get another 3 or 4 or 5 in addition. Texas would be the biggest one, and that'll be 5.
And when Governor Greg Abbott announced his agenda for the legislature's special session that started on Monday, redistricting was on the list. That's led prominent Democrats to talk about countering Texas with retaliatory redistricting in blue states. House Minority Leader Hakeem Jeffries is reportedly exploring the possibility of redrawing House maps in California, New York, New Jersey, and Minnesota. And California Governor Gavin Newsom has already laid out two options for retaliatory redistricting in that state, saying Democrats have to be aggressive.
They're playing by a different set of rules. They can't win by the traditional game, so they want to change the game. We can act holier than thou. We could sit on the sidelines, talk about the way the world should be. Or we can recognize the existential nature that is this moment.
Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, states are required to draw new congressional maps once a decade after each census. How unusual is it to redraw the maps at this time?
This kind of what might be called mid-cycle redistricting is very unusual. It's not that it's never happened before. It has sometimes happened. Although it's unusual, sometimes it happens when a new party takes over a state legislature that they hadn't had at the beginning of the decade. Here he's actually talking to states where the Republicans were already in charge of doing the districting in 2021 and saying, well, I want you to do it even more so now. And it's very rare that it's being done so kind of blatantly, nakedly partisan purposes. There usually is some justification for it, but this time, it's being announced as purely partisan, purely gerrymandering, rather than any claim that there was kind of a problem of representation with the older districts.
And the Supreme Court has said partisan gerrymandering is okay. Racial gerrymandering is not.
That's correct. I guess technically what they have said is that partisan gerrymandering is not unconstitutional. They don't endorse it, but they have said that there's nothing the federal courts can do about it. Racial gerrymandering, districting designed to help one race over another, that does raise a constitutional concern. But race and party are often very closely intertwined. And in their most recent cases, the court has basically said, if the state says it's partisan, because partisan is constitutional, we're going to defer them. We're going to put a very heavy burden of proof on the other side challenging it to show that it's not partisan, it's racial. And here, at least what's going on in Texas, the announcement is so clearly that it's partisan. And it seems to be that, but I think it would be very hard to show that even if there's a racial component to it, it'd be very hard to show that it wasn't primarily partisan.
Texas Republican Governor Greg Abbott said his decision to put redistricting on the list for the special session was because of a letter he got from the Justice Department that alleges that 4 of the current districts were racial gerrymanders that violate the 14th Amendment. Does that letter make any sense legally? Is it pretextual?
It sure seems that way. These districts were adopted 2 years ago, and they were designed to provide representation for minority groups, I think, for African Americans and Latinos. I think they were primarily Latino districts. The Constitution does not forbid that, and the Voting Rights Act actually, if it doesn't require that, at least it promotes that idea of fair representation for minorities. So no one has ever challenged those districts. And basically, the current administration seems to view that anything that even thinks about race is unconstitutional. That's not been the standard until now. The Supreme Court standard is that race can be taken into account in districting. It just can't be the overwhelming factor, the predominant factor. And I think you would have to show that these districts, of course, did help create minority representation, but you would have to show that that was the overwhelming factor as opposed to other factors, including respect for political subdivision lines, following the course of pre-existing districts. It does seem as though this was designed purely to give a justification for a redistricting. Without anyone going to court and suing, no one has gone to court to sue to challenge those districts. If anything, there was another lawsuit that was brought from the other perspective, saying that some other districts in Texas violated the Voting Rights Act in terms of limiting minority representation, and the state had been defending them, saying that the state's districting plan was entirely constitutional. So the state has now kind of flipped its position, moving away from its position that everything is fine, and is now considering redoing the district.
Rich, this could also be risky for Republicans, not just legally, but at the ballot box. Here's what former Texas Congressman Beto O'Rourke said.
And then it may come back to bite these Republicans because in order to create more competitive districts that they can win, they're going to have to lose some Republican voters in current Republican strongholds. So there may be an opportunity for Democrats.
Do you see a real risk here?
It depends on exactly what the Republicans do. But I think if they take some districts where Republicans are strong and move some Republican voters into nearby districts currently held by a Democrat but have been trending Republican. And I think what happened is that in the 2024 election, a lot of districts that are held by Democrats voted for Trump. And so I think what they're thinking is that they may be able to move some Republican voters from what are clearly Republican districts into districts which have been Democratic districts but might tip Republican with a few more Republican voters. So that's the idea. Well, I've seen numbers. They think they can find as many as 5 districts that look like that. What O'Rourke is getting at is they're risking the possibility that not only won't these districts tip, but by moving Republicans out of the other districts, they risk losing those districts. A lot will turn on what the political climate is next fall in 2026. If it's a Democratic year, that is a real risk. If it's not, then the Republican strategy may work. But, at some point, there are only so many Republican and Democratic voters in a state, and the idea is to try and arrange them in such a way to maximize your party's vote. But people don't always vote exactly the same each time, and it could be that some voters switch back, and the Republicans did very well in what had been Democratic districts last time. Will they do as well next time?
There's also a risk of retaliation. Minority Leader Hakeem Jeffries is reportedly exploring the possibility of redrawing House maps in California, New York, New Jersey, Minnesota, and Washington. And California Governor Gavin Newsom has been pretty blunt about saying, we're going to try to redistrict here in California.
I think it would be very hard to do this in California because they have a constitutional amendment that governs how redistricting is done. They would basically have to either supersede that amendment with a new amendment that either forever or for one time only that would change the districting process. That's really hard. I mean, I think they'd have to get something through the legislature and to the voters, and then the voters would have to approve that, and then they'd have to go and then write a new plan. And, that's a big lift. And whether or not they could get a constitutional amendment to the voters in time this year, and whether the voters would approve it, I mean, it's also pretty blatant. And although California runs Democratic, it's not clear to me that the voters would approve this. I mean, they might. And then, of course, they'd have to write a plan in a way that doesn't follow the constitutional pattern they have there. They have to come up with an entirely new system. So I guess they have to take it away from the Constitutional Commission and give it to the legislature, either always or this one time. I'm not sure what the proposal is.
And what about redistricting in other Democratic-controlled states?
Well, again, New York also has adopted a new constitutional format for redistricting, and that, I think, currently governs. I don't know about the other states. I think in the other states, it may be possible that the legislature, where they have a Democratic legislature and a Democratic governor. You mentioned Minnesota. I think the Minnesota legislature is very closely divided, and I think a key Democrat was just convicted of a crime and may have to resign, in which case it's not clear the Democrats have the Minnesota legislature. You mentioned Washington State. That might be possible. And you're talking about picking up maybe one seat, I think, in a place like that.
The term gerrymandering was coined back in the 1800s, so it's been around for quite a while, and both parties are guilty of gerrymandering. But has it gotten worse lately?
Oh, absolutely. Basically, because the computer power has gotten so much better, it has become much easier for computers to generate multiple maps, hundreds of thousands of maps that all comply with one person, one vote, and use pre-existing voting or voter registration data to maximize the number of Republican or Democratic districts. So it's no longer, taking out big maps and using crayon and drawing on the floor. You can generate almost an infinite number of maps by programming them to respect certain factors and not others. And that makes it incredibly easy. Now the level of, hyperpartisanship in the legislatures is such that they're also willing to do it. There's been something of a pushback, and I mentioned that California and New York have constitutional amendments that can try to limit gerrymandering. In a handful of other states, there have been limits placed on gerrymandering, either by constitutional amendment or by state Supreme Court decision. But where the legislatures are not limited, they have kind of infinite capacity to come up with maps that will do as much as possible to maximize the power of the party in power.
And it seems like the Democratic states are the ones with those independent commissions, et cetera, whereas the Republican states are still mostly relying on their legislatures.
You're right. And Arizona, which I guess is a purple state, has a commission. But I think, we're talking about California, New York, New Jersey, and then court decisions, I think, Pennsylvania, maybe now Wisconsin.
Well, there's a lot to watch with the maps and possible legal challenges before the midterms. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. You can't erase a tattoo, but can you erase a jury verdict about a tattoo? That's what photographer Jeffrey Sedlick is asking the Ninth Circuit Court of Appeals to do. The photographer sued celebrity tattoo artist Kat Von D over a tattoo she inked of legendary jazz musician Miles Davis based on Sedlick's copyrighted photograph of Davis. The jury took only 3 hours of deliberating before it returned a verdict for Kat Von D, finding that the tattoo wasn't substantially similar to the photo and didn't violate the copyright laws. But on appeal to the Ninth Circuit, the judges seem to be struggling to understand how the jury could reach that verdict when the tattoo and photo look alike. Here are Judges Kim McLean Wardlaw and Anthony D. Johnstone.
We look at it, we say this is the same photograph. Yet, through all these machinations, it ended up being the jury saying, oh, but it's not substantially similar. And I think it kind of defies rationality to suggest that it's not the same photograph. It is the same photograph. It's on a different medium. So how did the jury get where it got?
But I think we've also said that just transferring it onto a different medium can't alone be a difference, right? We're looking at similarities rather than differences. So if you have everything else is the same and we're just going to change it from being on photo paper to someone's skin, how's that?
But even if the judges thought the jury was wrong, what could they do about it? The Ninth Circuit has never reversed a jury verdict on substantial similarity, a subjective test. Joining me to answer these questions that the judges struggle with is intellectual property litigator Terrence Ross, a partner at Catton Muchin Rosenman. Terry, will you explain the test used here for copyright infringement?
So, in order to prove up a case of copyright infringement, you have to show ownership of a registered copyright and proof of infringement. The test for infringement in the Ninth Circuit, where this case takes place, is well developed over many years, a little bit complicated, but very well developed. And it's a two-part test with respect to substantial similarity. First, there is what's known as the extrinsic test, which is really an objective test, a fancy word for saying objective test. And that's undertaken by the court, by the judge, who determines whether or not there are objective elements that have been copied that constitute the literary work's expression, in this case, the photographic work's expression. So is there reason to believe that a protected element of the work was copied? Now, this is easier to do, in my opinion, in cases of photographs than in movies, television shows, plays, books, where small portions are copied and they slightly change the characters or the setting or the plot. And there, judges are really presented with a challenging first step in this infringement process that they have to undertake to determine whether or not protected elements of copyright were infringed, and they get help from experts on that. The second step, assuming that the copyright owner passes the first test, which is sort of a gatekeeping function that the judge performs, the judge then allows the infringement charge through the gate, so to speak, to the jury. And then the jury looks at the two works, engages what's known as an intrinsic test, which is essentially a subjective review. And the expression you often hear used in the case law is, does the look and feel of the copied work constitute an infringement, i.e. an improper copying of the original work? So there's this two-part test, part one done by the court, part two done by the jury.
So the judge in this case allowed the infringement charge through the gate, and the jury decided on the intrinsic subjective test that the tattoo wasn't substantially similar to the photo. But during the Ninth Circuit arguments, Judge Wardlaw said they were struggling to to figure out why the jury didn't find that they were substantially similar. She said it defied rationality, and it is the same photo, it's just in a different medium. And it seemed like the other judges agreed with her. Can they say the jury was wrong and reverse the verdict?
Not really. There are some rare instances where that's happened in copyright cases, but not in the context of substantial similarity. I know of at least two cases out there in the Ninth Circuit that involved the defense of de minimis use, where you take such a small portion of copyrighted work that the law allows you to do it. And I know there have been a couple cases where the appellate court reversed a jury finding on that. I've never seen it done in the context of substantial similarity case here. And a lot of this battle was lost by the plaintiff when the district court judge, the trial judge, ruled that this was not a case of substantial similarity. At summary judgment, the copyright owner, the photographer, had moved for summary judgment saying, look, this is no different than putting a book on a Xerox machine. It's literal copyright infringement, and we don't need a trial. And the judge disagreed, said it was not literal copying, and said that they would have to proceed to trial on a theory of substantial similarity. And in many respects, that cost them the advantage that they had, the copyright owner, because then you're putting it up for grabs with a jury. You just don't know how juries are going to come out, particularly where you have a celebrity defendant here, Kat Van D, who's apparently a famous tattoo artist in California, and potentially, more interesting trial counts in the courtroom presenting the case. And by all accounts, the defendant's trial attorney did a just fabulous job in the courtroom of getting the jury to understand the process that the tattoo artist went through and how that constituted original art in a way. So to a certain extent, got out-lawyered in the courtroom.
Some of the judges asked the photographer's lawyer to cite grounds that would allow them to overturn the jury verdict. And Judge Anthony Johnston saying it appeared to be beyond our review. I mean, is there any way, if they feel that it's obvious that this is not substantially similar and that the jury maybe was taken by the celebrity factor, I mean, is there any way that they would reverse the jury verdict?
So let me start off by saying this. The counsel for the photographer who argued before the Ninth Circuit is a well-known, well-respected copyright lawyer by the name of William Patry. He has written one of the leading treatises on copyright law, was the copyright lawyer for the House of Representatives during several periods of time in which really significant revisions were made to the Copyright Act, and then taught copyright law for a number of years. Very well-respected, knows copyright law. As you say, this question was put to him before he had completed his first sentence at oral argument before the Ninth Circuit. Can we do this? Can you cite us to authority that allows us to do this? And the only cases he was able to cite to were not in the context of substantial similarity cases. They were in other contexts. And certainly from listening to the argument on tape, I came away convinced, as apparently you do, that the judges would not have reached the same verdict as the jury, but we're going to respect the jury's verdict and affirm it. And this is the whole problem with losing on the second part of the test, the intrinsic subjective test that depends on the subjective view of the jury as to the look and feel of the two works. You cannot substitute, as an appellate judge, your opinion for that of the jury's. And so I don't see any way that this is going to be overturned.
I love this line from Photographers Council. We don't know what the jury did, and we don't know what the mystery of Stonehenge is either, but we do know the jury should never have done this. It must be frustrating to have, judges see that a jury made a mistake and still can't do anything about it.
As a baseball guy, the only analogy I can give you is to umpires calling balls and strikes at home plate. I mean, it's absolutely verboten for a manager or a player to challenge the calls of balls and strikes. In some sort of objective sense, measured by a robot, the ball may have been slightly outside the plate, but that does not make it a ball. The call of the umpire makes it a strike, and for all purposes, it is a strike. And to go around saying, got that call wrong, no, there's no appeal from that. And it's the same with a jury verdict. For the most part, absent fraud the jury being bribed or something like that, the jury verdict stands up because you're not allowed to replace your view, your personal view as a judge, with that of the 12 men and women of the jury. It simply isn't done in Anglo-American law. And that's the problem you hear expressed at the oral argument from these judges. They would have decided it differently, but they realized that they're handcuffed.
Terry, Judge Johnstone seemed to have some broader concerns.
I guess my concern is we're kind of washing out the value of and the principle of copyright by allowing a jury to reach unreviewable subjective determinations on an intrinsic test.
So he's complaining about the test that has been established in the Ninth Circuit, and not just in the Ninth Circuit, in multiple other circuit courts. You know, the Sixth Circuit, where you have Nashville and Detroit, you get a lot of copyright cases. Second Circuit, where you have New York, you get a lot of copyright cases. Seventh Circuit, Chicago, you get a lot of copyright cases. All these courts have adopted this test, although it was pioneered by the Ninth Circuit. I mean, that was 35, 40 years ago, and it's lasted the test of time. In the majority of cases, it works. In this one case, you might be able to argue the jury got it wrong. I actually, unlike you, June, see some differences in the photograph and the tattoo. Now, whether or not they're enough to have me vote non-infringement, I don't know. Haven't thought about it enough. But the complaint that the judge here has is fundamentally a complaint about existing law. And in order to change existing law, somebody is going to have to petition for an en banc review at the Ninth Circuit. So what should happen here is the panel of three judges affirms the jury's verdict, and then the photographer, the plaintiff, files a petition for review en banc, meaning the entire Ninth Circuit, all the active judges of the Ninth Circuit, sit and reconsider whether this is the appropriate test. And that perhaps is what is being suggested here, but it is sort of like, whistling in the wind. There are always going to be jury verdicts that people think the jury got wrong, and that's going to be in civil cases, and that's going to be in criminal cases. It's fundamental to our jurisprudence that we accept that margin of error in order to allow the sort of due process we want to have, i.e., to have regular citizens decide cases. And I think it's very misplaced for an appellate judge on a prominent court of appeals like this to, in effect, badmouth the jury.
We've talked about copyright and tattoos before. Does this stand for any broader principle about, tattoos of copyrighted works?
I don't believe it does. I don't believe it stands for any broad principle in copyright law generally. Both attorneys, the attorney for the photographer, attorney for the tattoo artist, when asked this question at the Ninth Circuit oral argument, said that they did not believe the decision here impacted more broadly than the dispute between the two parties. And I agree with that 100%. This is a relatively run-of-the-mill copyright case. It doesn't set any new copyright law. It doesn't set any new precedent. And that's why I'm not super concerned about the fact that maybe the jury got it wrong. Jury verdicts don't set precedents. And so the law will continue to be the same, and the next jury might have a completely different view of a tattoo. But in all cases like this, I come back to this fundamental proposition. The courtroom is not a neutral playing ground. It is shaped by the attorneys on either side, and there are attorneys who are really good trial lawyers, who are really good in a courtroom, and who can shape the case and the jury's verdict of the case in a manner that benefits their client. And there are lots and lots of attorneys who don't fit that bill. And that's more often than not the real explanation for why a particular case comes out one way or the other. For people who simply hire lawyers without considering, well, if this case goes to trial, how good is my guy, my girl, going to be in the courtroom doing mano-a-mano battle? And they simply don't consider things like that. And that's a mistake. And you get what you deserve when you make that kind of mistake, and you don't hire a really good trial lawyer. And, I wasn't there for the trial, but based on what observers did say and everything I've heard about the case, it seems to me that the combination of a celebrity defendant and the defendant out-lawyering the plaintiff may have led to what at least these judges on the Ninth Circuit felt was a wrong decision by the jury.
Thanks so much, Terry, for those insights from an experienced trial lawyer. That's Terrence Ross of Catton Muchin Rosenman. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.